Its real name, the Affordable Care Act. Its real impact on the 40 million plus Americans without health insurance and the rest of America. We'll ask Edward Hartnett, professor for constitutional and public law and service at Seton Hall University. Thanks for joining us today.
Thanks for having me.
Let me ask you, is there a big surprise, or was this something you expected?
Well, frankly, I think the biggest surprise here was not so much about the individual mandate, where most of the attention has been. Actually, the biggest surprise was on the Medicaid side. That 7 justices, 7 of the 9 justices agreed that when Congress expanded the Medicaid program, dramatic expansion of Medicaid program, and said to the states, if you want to accept any Medicaid money, you have to accept these new conditions on that. 7 justices said Congress went too far, that all Congress can do with its Medicaid expansion was to say, states, you've got a choice. You can accept our new conditions on vastly expanding Medicaid, and if you say no, then you lose the new Medicaid money, but you can hold on to the old Medicaid money. 7 of them said it's too much for Congress to say, if you don't like our new conditions, you have to give up Medicaid completely.
Wow.
That was the big news, that 7 justices, for the first time ever, concluded that Congress had gone too far in coercing the states to accept conditions on spending. First time that ever happened.
And we're not hearing about that. We're not hearing also about the constitutional issues that are at the heart of what was considered this huge decision that the Supreme Court made.
Right. I mean, the piece that everybody has focused on is the so-called individual mandate. And I think to understand that in constitutional terms, understand what the Supreme Court was getting at here, it's important to start basically where Chief Justice Roberts starts. And that is by making clear that the national government isn't given the power to do all things that are good and wise and just, not given the power to do all things that governments do, but instead is given a list of powers, a list of enumerated powers. So for the government to act, for the federal government to act, it has got to point to something on the list, basically, in order to justify the powers. The so-called individual mandate, the requirement, as the law seemed to be, that virtually all individuals purchase insurance, was justified on 2 possible grounds. One, Congress's power to regulate interstate commerce. The second was Congress's power to impose taxes on people. And what 5 justices say is Congress can't use its power to regulate commerce to make people buy things. That exceeds congressional power. Congress can't make you buy health insurance, can't make you buy a car, can't make you buy green vegetables, can't make you buy anything. But what Congress can do is make you pay a tax. And what 5 justices said is what everyone's calling the individual mandate, the obligation to buy insurance, isn't really an obligation at all. It's just a tax, and it's okay if we view it as just a tax because Congress has the power to tax.
So then, if you don't pay the tax, given that analogy, then you've got to pay the price.
Well, what's interesting is, that's what I'm getting at the question: what's the difference, right? If the law is still in place, right? If the court didn't say this law is completely invalid, what's the difference? Well, I think the difference is there's a difference between telling somebody you must do something, and if you don't do it, you're violating the law, you're violating our community's standards, you're violating your duties to the rest of us. And if you don't do it, we're going to punish you. So the difference between that and saying, look, you've got a choice. We'd like you to do this, and if you do, we'll give you a tax incentive to do it. But if you don't do it, you're not a lawbreaker. You're simply somebody who has to pay some more tax. In effect, what the majority of the court did, basically Chief Justice Roberts did, because he controls the court on this issue, was basically make the individual mandate no longer a mandate, and effectively said it's like the incentive to to buy a Toyota Prius or to buy high efficiency furnaces for your house.
Instead of an SUV.
Yeah, it's a good thing to do. We'll give you a tax break if you do it. We'll charge you more in tax if you don't, just like we'll charge more for if you buy cigarettes. We're going to put very heavy taxes on it. But you've got a choice. You can do it if you want. If you don't do it, you've got to pay it. You've got to pay a little extra tax. And if you do it, then there'll be some extra taxes that you don't have to pay.
So as you see this, there's not this onerous punishment for not getting health insurance.
Yeah, I mean that's. I mean, there was never an onerous punishment, right? I mean, it's not as if that the mechanism changes. I think for the vast majority of people, given how Congress made this so-called penalty now viewed just as a tax, the way it made it work, for almost anybody who doesn't buy health insurance, the only way they're going to notice it is they'll get less of a tax refund when they file their income tax.
Wow.
That's the on-the-ground impact, however you label it, whether you labeled it a penalty or you labeled it a tax, that on-the-ground impact hasn't changed. What maybe has changed is sort of how people may respond.
And we've never heard it couched that way before. And that's the great part about having you here. Let me ask you this. Precedent setting either way?
Well, no, I think that's right. I mean, on the Commerce Clause side, right, on the question of does Congress have the power to make people buy a product that they don't want to buy, to enter into a market that they are otherwise staying out of, no matter what the court did here, it would be establishing new precedent, making new law, if you will. Why is that? Because Congress has never tried to use its Commerce Clause power this way before. It's required people to buy things using other powers. But under the commerce power, the requirement to actually enter the market, at least is widely understood to be that's new. So whether the court said, no, Congress doesn't have the power, as 5 justices said, or 5 justices were to say Congress does have the power, either way it would be establishing new doctrine, new precedent, and people on either side would be able to say either, oh wait, the court just imposed this new limitation on Congress that nobody ever knew existed before, or that Congress has endorsed this new power of Congress that nobody knew Congress ever had before. Either way, the opponents would be able to say, hey, there's something new here. And on the Commerce Clause side, there are 5 justices who said here that Congress doesn't have this power under the Commerce Clause.
It's enlightening stuff. I don't think most people have gotten that kind of an education about the impact of a Supreme Court decision. It's really been interesting. Well, thank you for coming on board to explain some of that with us. We look forward to having you back again to delve into more constitutional issues.
Thanks for having me. Be eager to come back.
It's a pleasure.